David Parker.
Thank you, Mr Speaker. As the Honourable Trevor Mallard has said, we will be opposing the motion in part because it's been introduced under urgency. And I wanted just to state some of the principles that lie behind why it is that we generally have longer select committee processes than is being provided for if this motion is passed. Mr Speaker, standing orders were changed in this Parliament because there is recognition across Parliament that one of the few protections that we have against unwise legislation lies in a proper and fulsome select committee process. A select committee process that is long enough for the issues that are or might be of concern to be thought about properly by submitters who could have time to reflect on complexities and submit, and then time for select committees to properly consider the issues that are raised by submitters. And let's take this case in point. Mr Speaker, in this situation we are dealing with the conflict between monopoly rights of copyright holders and some of whom want to restrict parallel importing of films, and they say that's in part because they want to protect the local cinematic projection, the film, the cinemas. Mr Speaker, I for one am a believer in copyright. I believe it's important that we protect the rights of the creators of creative content to get an economic return on their creativity for a period of time. And if we don't have copyright, we would be worse off as a society because the creative work of authors or filmmakers or painters or sculptors would be less, because they wouldn't be able to get as much of a return from their creative efforts, because someone else could just be able to rip them off the next day and produce a copy which could be sold at a cheaper price and wouldn't enable the salary or the profit to be paid to those that produce the creative content, and therefore you would have less creativity or creative output in society. Now, these things have to be founded on their underlying principles, because the other side of that, and we see this issue coming up in the Trans-Pacific Partnership at the moment, if you extend the term of copyright beyond a fair period, then the disadvantages that accrue to society of having conferred monopoly rights to a monopoly property right in respect of copyright are extended in a way that's disadvantageous.
Can I just remind the member that when we are doing these debates here, it's a very restricted debate. It's not a debate on a much wider subject. It's actually restricted to the special powers on the instruction of the Committee of the Whole to have a truncated report back period at the Select Committee. And there is a standing order, 2863. So I just ask the member and other speakers just to be mindful of that. Yep. While you can certainly canvass other things, it must be restricted to the special powers or instructions that this motion's about. The Honourable David.
Thank you, Mr Speaker. And I'm just about coming to the end of this point, but the point I was trying to make is that some speakers have said, oh, this is a simple bill, it's only a small number of clauses, therefore there's no difficult principle involved and we can have a truncated period. And I was trying to illustrate that this tension between length of copyright and the interest of protecting creative content compared with not extending copyright periods beyond the period that's necessary to generate or to encourage that creative content is where the policy tension arises. And it's quite proper of other parties like the Green Party to say, look, they haven't made their mind up on this yet, they're abstaining on this legislation at first reading, so they haven't got to the position yet, Mr Speaker, as to whether they know that whether this legislation should be supported or not. Neither of New Zealand First, and that shows that there are some complexities that surround this legislation, which means that a fulsome select committee process could be necessary in order to tease out the issues. Mr Speaker, I don't actually understand properly where the tension lies here. Is it really the copyright holders who are saying that they want there to be a restricted period free from parallel importing. If that's the case, then I'm quite sympathetic to that view, because a lot of the parallel imports, some of which may actually be in breach of copyright, because the right to copy and distribute DVDs might have been constrained with their agreement with the original copyright holder. I'm not sure whether this has been driven by the copyright holder of the film, or whether it's been driven by the cinematic industry, and I think that's a very relevant thing that the Select Committee should have time to explore. Mr. Speaker, I thought that the comment that the Honourable Trevor Mallard made in his contribution was valid too. Why is it that this legislation is so late as to be introduced now, when it has to be passed by the 31st of October 2013, according to the government, to meet the expiry date of the existing legislation? Well, the answer is that it's up to the government to introduce legislation in sufficient time for it to be properly considered in advances of deadlines like this. And I'm surprised that they didn't introduce the legislation earlier so that they could have a decent Select Committee process. The second point, though, that follows is, given the reality that they are now where they are, and from now, if you had a normal sort of 6-month period from now, you would go past the 31st of October, well, Trevor Mallard makes two good points then. Firstly, with a relatively simple bill like this, you would expect that the Select Committee would clear this off their agenda and bring it back to the House well within that 6-month period. The government controls the majority on that committee. They could ensure that there was a fair, not overly prolonged period, and they could get it back pretty promptly. Would that be by the 31st, by the 16th of August, in a way that enabled the new legislation to be passed by the 31st of October 2013? Well, it would be there or thereabouts. And if it was a bit late, what would be the great harm caused by a hiatus? Does anyone really think that for a hiatus of a 1-month period, the industry is going to change what they do and bring in parallel imports in respect of films that might be released in New Zealand during that, or might be released overseas during that short window? I don't really think that that would be likely to be a big problem.
So what's the problem?
And if that's right. No, that's right. So if there was a slight detriment from that occurring in the occasional case, the world's not going to end. And as a consequence, the more proper principle to be given primacy is not to override the normal Select Committee process, which this government has got into the habit of doing, and doing often. We've had it not only in respect of this bill, but we've had other bills. We've had it done under urgency. We've had bills pushed through all stages under urgency with no Select Committee process, as I think was the case in respect of the ouster clause, ousting the jurisdiction of the court in respect of family members who provide care for disabled members of their family. So that was an even worse example of an abuse of power, but this is somewhere in that spectrum. It's not nearly as bad, but it's still bad. We've had other things that have been done through poor process in respect of supplementary order papers being introduced that didn't go to Select Committee, that introduced new concepts, and we saw that in respect of the truncation of the right to protest at sea, which was done by way of Select Committee process, supplementary order process that didn't even go to Select Committee, Mr. Speaker. And so there's a habit forming with this government where they are abusing the proper processes of the New Zealand democracy. And as I commenced my contribution, sir, by saying that in New Zealand we have very few protections against hasty or ill-considered legislation because we have but one House of Parliament, and as a consequence the protections that are to be found in Select Committee processes are all the more important, and one of the most important processes is time to enable people who might have a contrary view to that which is espoused in legislation to understand the issues, to get the others in support to back them, and to get the Fourth Estate on their side. Now, the Fourth Estate might have a view on this, but they won't really have much time to get their head around it because the report back period is so short. Now, what this effectively means is to have a report back period date ending the 16th of August, the advertising period has to be much shorter than that. So there won't be much time for the public to make submissions on this. Having said all of that, I don't want to say that this is as bad as those other examples where we've had ouster clauses, ousting the jurisdiction of the court, or truncating civil liberties through a supplementary order paper. but I do think that this is a poor process, and for that reason, amongst the others that Mr Mallard has articulated, we will be opposing this motion.
Jackie Dean.
I move that the question be now put.
I'm going to hear Chris Farfoy.
Thank you very much, Mr Speaker. Tēnā koe, and can I also join